Hey guys, it's Josh, and in today's episode, we're going to talk about the wholesale real estate contract process. Now, this is a very important topic because every single wholesale deal that you could possibly get, you're going to need to have a contract in place. And it's important to understand what's in the contract, and that's going to help you explain it to your sellers, which is going to help you make more deals and more money. So if you're new to the channel, guys, make sure to smash that like button below. And if you're getting something out of this, click the subscribe button and hit the bell for notifications. We drop videos like this all the time to help you crush it and make more money in real estate so that you can have an awesome lifestyle. So let's get into it. All right, so we're going to talk today about the purchase contract for wholesale real estate. And we're going to talk a little bit about the process. Now, there's 30-something key phrases that are in the contract. And guys, I've been a licensed real estate agent here in Arizona. I'm going on my 12th year. So I have literally filled out thousands of purchase contracts. And majority of the contracts I filled out in my career have been wholesale. I would say probably like 85-90% of the contracts I've done in my career have been wholesale, and 10 to 15% of them have been retail, which is still, you know what, actually it's probably a higher percentage than that. I've done hundreds of retail and over 1,000 wholesale contracts, so it's been a lot of contracts. We're going to focus today on the wholesale contract, and you can use this whether you are licensed or unlicensed, but I wanted to give you a little bit of a background that I have a lot of experience with contracts. In fact, part of being a real estate agent and now broker is you have to get so many continuing education hours in contract law every single year for the state that you're in, as well as I've spent literally tens of thousands of dollars on I can't talk. I spent over $10,000 with attorneys in getting my contract to where it's at right now and having the right wording and clauses and stuff like that. So, disclaimer, I'm not a real estate attorney, and I do advise everybody to get legal counsel, get accounting counsel, get insurance counsel, and I talk about the importance of those aspects in other videos, but I want to focus on the contract today, and most of what is applied in this contract is going to apply, I would say 99.9% to every single state out there. There's a couple little differences I'll cover whether you are like an escrow state or a closing attorney state, but it's the same process and the same contract. You just might interchange a couple of words, so I'll go over that. So let's get into it, guys. The first thing that you need to have on your purchase contract is you need to have the seller and the buyer. All right, now, a lot of times people will, with the wholesale contract, something they intend to flip this contract or assign it to make a wholesale fee, they're going to put buyer and or either assignee, or they'll put and or nominee. Now, in my state of Arizona, you don't need to do either one of these. In fact, a lot of people don't know, but real estate contracts in Arizona, did I just say that? Real estate contracts in Arizona are assignable unless otherwise noted. In fact, that goes for all contracts in general contract law in Arizona. So in other words, unless the contract says you can't assign it, you can, and you don't need to have this clause. Now, you might want to look into that for your state. That could vary by state, and maybe you do need to disclose in there that it's assignable. Or in some states, I know like California, they have in their contract, in their real estate forms that the realtors use, it actually does specify and it says this is not assignable. So you would have to modify it if you're using a realtor form. But the wholesale form, ultimately you're going to have the seller and buyer's name. From there, you're going to have the witnesseth clause. Witnesseth. Now, sounds fancy, but essentially all that says is what's taking place. So it's saying the seller and buyer. It's saying the seller agrees to sell the property, the buyer is going to give consideration to the seller. Now that could be cash, that could be a loan if it's seller financing, etc. But this clause is basically just saying the purpose of the contract is for the seller to give the property to the buyer and the buyer to give the seller financial consideration. Under the witnesseth clause, you're going to have the property address, the full property address, and then under that you're going to have the parcel number, which identifies the property a little more specifically than the address with the county or municipality. And then you're going to have the legal description, which takes it even a little more further. But all three of these, the address, the parcel number, and the legal description, just say what is the exact physical place where the property is that's being sold. And this is really important that you have these, all three of these on your contract, guys. I one time did a deal, this was years ago, in the state of Washington. Couldn't find the legal description because I was using the tax records for Arizona. I was used to using the tax records for Arizona. It was Washington. I spent a couple minutes, couldn't find where the legal description was for this property. I thought, it's not that big of a deal. Well, this deal later fell apart. The seller wanted out. We were going to make probably about $35,000, $40,000 on this deal. And the seller wanted to back out. And she got an attorney, and I had my attorney take care of it. And they got together, and I found out the hard way that in the state of Washington, and I think it might be like this in several states, if it's not a full legal description, that can void a contract. This can be argued in Arizona as well. I do know. I haven't had it happen. I actually had it happen in Washington. So just spend a minute, find the legal description, make sure you have the right parcel number, make sure you have the right address. Pretty basic stuff there, guys. Then you're going to have the sales price. Sales price. Now, the way I do it, I put the dollar sign, the number amount, and then I write it out in words, 100,000 US dollars or something. It's basically the same way you would do it like on a check. That's the way I like to do it. If you want to put just numerically, you can. I think it's better to have it numerically and just write it out next to it. Then you're going to have earnest money deposit. I'm going to title this EMD, earnest money deposit. That's the money you're going to put down to make the contract binding. So you're going to place this money typically with the closing agent or the escrow company. But this is just a deposit saying, in good faith, I plan to purchase this property. I'm putting down a deposit. Now you can make that deposit contingent, and we'll get into that here in a minute, or you can make it non-refundable for any reason. That's a tool you could use depending on if there's other wholesalers maybe making an offer on the property. You're trying to make your offer more strong, etc. But it's up to you. I will cover the contingencies so you can protect your earnest money for sure. If you're just getting going, you're like, that's my last $100 that you use there, you can protect it. And the going rate for earnest money is going to vary. A lot of people out there will use $10 for wholesale contracts. I'm a little bit different. I usually will use $1,000, sometimes $3,000, $5,000, 10% of the purchase price is what I like to do. The reason I'm that way, I have a lot of experience. I have good legal counsel. I have contingencies in my contract. So I like to put something there that sounds reasonable. I can use that as, to show the seller that I'm really serious, that I really want to buy this property, that we're the real deal. And if other people are sending a contract and it's a lower amount, I can use that for credibility. So, if you don't have a lot of money, you can do a smaller amount. I know wholesalers in other states that do a lot of deals, and they just say, we do 150 on every deal, and that's it. So the way I do it, I have 150 on my template, but we often change that to 2,000, 3,000, sometimes 510. One time I put $50,000 earnest money down on a deal. We assigned that deal and made almost $70,000. So it worked out. I knew it was a good deal, but the seller, it was a luxury property actually. We don't wholesale a lot of luxury properties, but you do enough marketing, you're going to get deals everywhere. And the seller wanted $50,000. They were moving to their other property in Florida. They wanted to be 100% sure it was going to close before they started doing anything. They wanted 50 grand down. I knew it was a deal, so I said, no problem. After earnest money, you're going to have the closing agent. Now, this can be an escrow company, like a title company, or it can be an attorney. It depends what state you're in. So like I've done deals in Atlanta, Georgia. They use a closing attorney. Here in Arizona and up in Oregon, we use title companies. Same thing with Indiana. Those are the states I've done a lot of wholesale deals in. But it's the same thing. It's a third party that's going to make sure that the terms of this contract get abided to by the seller and by the buyer. That's it. The earnest money typically will go to them. Although in some cases, in some states, the earnest money goes directly to the seller. It's always applied towards the purchase price. But I always prefer, doing business if possible, having it go with the third party. So if it gets into an argument over canceling the contract, as long as you're within the bounds of what the contract says, you're not going to have any issues getting your money right back. After the escrow company or closing attorney, it's going to have what we call COE. That stands for the close of escrow date. That's just the date that we're going to close. And I always like to put on or before in my contracts. A lot of times we'll do a 30-day contract with the seller. The house is vacant, but then we'll assign it really quick and the seller's already moved out, and we'll tell the buyer they got to close in 7 days so we can get paid sooner. And it's nice to have that on or before. We don't need to go do an addendum. We can simply call the seller up and tell them, hey, great news, we're going to close early. Our funding partner's ready to go. And in this case, then obviously we let the title company know, hey, we're closing early on this one as well. You could do an addendum there if you want, but it's not necessary because your contract already says the date on or before. Mortgage clause. That's going to say that if there's any mortgage owed on the property or mortgage is owed on the property by the seller, Those will be paid off at close of escrow, and it's going to be clear title to the buyer. After that, you're going to have the judgments clause. This is the same thing. It's saying that there's no judgments on the file. If there are any, they're going to get cleared at close of escrow by the seller paying them off. So these are things to protect you as the buyer to make sure it's going to be clean title. You've got the lead-based paint, and I call this the LBP. If the property was built before 1979, it could have lead-based paint. In fact, realistically, it probably does. Just like most old houses probably have asbestos. The important thing here is just to keep everybody safe. So when you go to assign that contract, or if you sell the property, you need to disclose always, hey, this was built before 1979. It could have had lead-based paint in the past. If you know it existed, then you're going to specify it did, but most of the time you're not going to know. You're just going to need to disclose that, hey, it was built before 1979. It may have been painted by lead-based paint in the past. In fact, probably was. This isn't a big deal because every property that was built before 1979 in the country has the same issue, but it's important to have that disclosure. If somebody buys it and you didn't have that in there, they come back and they got sick or their kid ate paint chips or something, it starts a chain of lawsuits, somebody's butt's going to be in trouble. So just have it in there, protects the seller, protects you if it was built before 1979. You're going to have an access clause. And that's basically going to say that, the buyer agrees. Mine's really simple. I don't have it say they're going to give me a key or anything like that, or that they have to let me in within an hour or anything like that. I simply just have it say that the seller will allow access to me as the buyer to do my due diligence, inspections, and market the property. Now, realistically, I just want to get the contract signed. After I get it signed, then I worry about getting pictures. Unless I'm already at the property, then I get it signed and get pictures at the same time. But say I get it over like email, they docu-sign it, now I have a new contract. I'm going to call the seller and I'm going to try to get in the property, get my pictures as quickly as possible. But I'll work with them. I want to make the experience as pleasant as possible for the sellers. But once I have the contract, it is nice to get those really quick so I can get the deal sold, obviously. And once I get it sold, I'm going to need to arrange access for a walkthrough for my cash buyer. Not mandatory. In fact, I sell most of my houses. I would say 90% plus of our wholesale deals get sold sight unseen. The buyer has not touched the property other than maybe a drive-by prior to signing the contract and depositing the earnest money. However, once we have them locked in, they have an assignment contract signed with no contingencies. They've deposited in my case, I do $10,000 on every deal, earnest money. I know we're good, we're gonna close, and then I do set up a walkthrough. So I tell them on the front end, I say, you'll be able to walk it, you'll be able to see what you're buying, but we can't do a whole bunch of walkthroughs because the seller's trying to avoid that. That's going to make them feel nervous, etc., etc. But that's why you're getting such a great deal. So that takes care of that. But just have an access clause in there so that if they say, nope, you got to close before you can come in here again, you're not stuck. And you can point back to the contract and say, no, there is an access clause. We need to be able to do our basic things, to buy this house. And shouldn't be any problem at all. The closing costs addressed. You're going to have the closing costs addressed, and they're going to simply say that you as the buyer are paying all closing costs. That's the easiest way to do it, because then you can negotiate with the seller and they know the exact amount they're getting. They're not trying to estimate, okay, well, the price is this, but I'm going to have these fees. No, you want to make it simple for them. My price is this, that's what you're going to get a check for, minus whatever you might owe on your mortgage or if there's a judgment. So it keeps it really simple. You're going to pay all the closing costs. Those are going to be passed off to your buyer that you signed the contract anyways. So if you lock this thing up for $200, you assign it for $220, you're going to make 20 grand. Those closing costs, the final buyer is going to pay those because the contract says the buyer's paying them and he's taking that over. Wholesale deals, cash buyers, they know that they're going to pay all the closing costs, so it's not that big of a deal. But you can use it as you're talking to the seller to get that contract signed. That's huge value that you are going to pay those title and escrow fees and all those closing costs. Obviously, they are going to be responsible for their own taxes. We'll get to that here in a minute. Agent clause. And the agent clause is going to say that both you as the buyer and them as the seller are not acting with representation by a real estate agent. Okay? Unless you are a real estate agent and you're choosing to represent yourself. Then you would need to say, I'm representing myself, not representing the seller, and the seller doesn't have anyone representing them. Unless they do have someone representing them, and then you would say, me as the buyer does not have anyone representing me, unless you are, but they do have an agent representing them. So you just want to spell out who's representing who. Most of the time, no one's going to be representing anybody. And so it's just going to say neither party's being represented by an agent. Each person's acting as a principal. License disclosure. So like mine says that me as the CEO of my wholesale company holds a broker's license in Arizona. Even if I'm buying a property in another state, I disclose that. But then we also disclose that the entity is not licensed. So in other words, they know that Josh Gaiman has his broker's license in Arizona. However, Easy Button Home Sales here in Phoenix is not a real estate brokerage. It's a principal. It's just an entity that's buying the home. It's a real estate company, but not a realtor brokerage. It's not representing them in any shape or form. Contingency. And we call this funding, I don't know if you can see that very well, funding partner approval. Okay, now you can do that, or you can do due diligence, and I would say usually do 7 days or 7 to 15 days, depending on how much time you think you need to market and get this property sold. You can click this link right here, get an instant cash buyers list for any market you're in. And if you get an amazing deal tomorrow, it's going to sell like that to that list because you'll instantly have thousands of cash buyers in your market. But I use both these clauses. It just depends. If I'm dealing with somebody, they have a real estate agent involved, or they used to be a real estate agent, or they mentioned somebody in their family is, or anything like that, I'll usually go for a due diligence clause because it's more normal. That's what retail transactions do. They'll say, buyer has 7 to 10 days to do inspections, check out the property, make sure everything's good. I like with wholesale to just do funding partner approval for 90% of the contracts. They don't even really think much of it, and it doesn't have a deadline. But if it's somebody that's like, well, what do you mean funding partner approval or deadline or anything like that, you can go with the due diligence. So go with either one. Honestly, it rarely comes up that the seller even asks anything about it. And if they do, you just say, well, hey, that's just for me to do my basic stuff, have the title company pull the report, make sure everything's good, run it past my partners, but we're good to go. Give them confidence that, your intention is to close this deal, because it is. But obviously, any real estate contract's going to have some type of clause. So I like to simplify it with funding partner approval in my wholesale deals. Again, unless, like I said, unless they're working with an agent or they have an agent background or something like that, then I'll do the due diligence for 7 days just to kind of normalize it. Or you can even do due diligence for 2 or 3 days if you've got that list I talked about, the agent cash buyers list that you can sell a property like this to. You're going to have the investor clause. And I'm running out of room. I'm going to have to start another column. Investor. And the investor clause says that I'm an investor. I'm doing this to make money. Now, you don't necessarily have to do this in every state or in every instance, but I think it's important. You don't want them to come back and say, wait a minute, you gave me this sad story, you were buying it for yourself and blah, blah, blah. You're like, no, we're doing it with the intent of making a profit. Now, you can disclose that it's to flip it or to rent it or whatever. You don't even have to say any of that. You can just say, we're buying it as an investor with the intent of making a profit. And when you can let them know, hey, we have different exit strategies. We might hold it for a while, we might sell it, but anything we do, I'm not moving into it. I think that's important, especially if you have a real estate license. If you don't have a real estate license, it's probably not as key, but it is a good disclosure if you do have your real estate license, just to protect yourself. And again, you can run this all by your local attorney in your market as well. We've got the default clause. Now, the default clause says that if I, as the buyer default, breach the contract in any way, I'm not able to close, etc., that the sole remedy for the seller is my earnest money. So if you put down $150 or you put down $1,000, whatever you put, that's your maximum exposure. They can't come back and sue you for what's called specific performance and say, hey, you signed a contract to buy my house and you didn't buy my house and you owe me all this money. They can't do that because they already agreed in this contract that earnest money would be the sole remedy. So that's your max exposure. You still have contingencies, so you should never, in theory, have to worry about giving up your earnest money anyways. But if it does become a thing, at least you're capped, and if you do a really small earnest money amount, you don't have much exposure there at all. Now, it says that's only for you as the buyer. The clause doesn't say anything about the seller. That's how you want to have it, so that if they default, you can pursue specific performance. Say you have a deal assigned and you're going to make $40,000 and the seller decides they don't want to close, you don't want to just get your earnest money back. So if you have this say that earnest money is all that's at stake for both parties, you can end up screwed. Only have the earnest money be the sole remedy if the buyer defaults, not the seller. And there's a link below, I'll talk about the end of this video, guys, where you can get an exact copy of my contracts with a more in-depth overview so you can implement all this stuff in your business immediately. All right, after that, we have the lease clause. Now, this only applies, obviously, if the property is rented, but basically it says that within 48 hours, the seller will provide to the buyer, any payment history from the tenants, a copy of the lease, how much the deposit is, etc. If they don't have that, say the property's leased, but they don't have anything in place, find out what the verbal agreement is and make sure to include that in the purchase contract. So if they say, no, I don't have a lease, They say they've run it for 3 years, and there used to be a lease, but I lost it, or there never was a lease, but they pay $700 a month every month. Well, then that's a month-to-month lease, and you would just put in the contract, tenant is month-to-month and pays $700, and then you would ask him, is there a deposit? Yeah, there was a $500 deposit, and you would put that on there. I always recommend too, if that's the case with rents and deposits, try to confirm it with the tenant if you can prior to closing. That's going to help with your buyers a lot, to know the exact story there, because you don't want it that seller says, yeah, there was a $1,000 deposit, and then you close on the property and the person moves out later and you find out that they said that there was a bigger deposit, or there was etc. And then all of a sudden now you're on the hook to pay them the deposit back, but the seller's long gone, they got their money and left. So I always like to confirm that if possible, what the lease details are. Again, that's only if the property is currently leased out. We put all seller-owned appliances convey. I've never let that kill a deal. So if somebody wants to take their $50 washer, their 7-year-old refrigerator, it's not a deal breaker. But ideally, it's good to have all appliances there, and then when you market it, you can say it already has all appliances. Because usually they work. They're typically going to be functionable, unless it's a horrible house. I'm going to call this a closing extension clause. This is really important, guys. I added this to my contract years ago because here's what happens. Say you don't close on time, but it's because the seller wasn't ready. And then the seller says they want to back out. And they say, well, the contract was to close by this date. We didn't close by this date. It's void. This clause protects you. It says that should closing be delayed at no fault of the buyer, escrow to be automatically extended until seller can close. So if there's a holdup with the payoff, with the county, with anything, the seller can't just say, oh, I changed my mind, we didn't close on time. No, it automatically extends until they choose to. Now, it only says the seller, so you still have to have your money ready to go and close on that day. And if they get, sometimes people will read that and they'll say, well, wait a minute, what's this about automatically extending? No, I want to make sure we close on time. You just explain that to them that, no, this is only for you, Mr. and Mrs. Seller, if there's any delay getting your payoff or something like that. Me as the buyer, nope, I'm going to be ready to go on this date that we agreed to on or before. We've got the legal dispute clause, and I'll be honest, sometimes I delete this. Because what the legal dispute clause says is that in the event of a legal dispute, the prevailing party is to be awarded attorney fees for litigation. Now, here's why that's in there. If you go to court, there's a dispute, you can say, well, when I beat the seller, because I'm in the right and they're in the wrong, I also want them to pay my attorney fees, and they already agreed to it. Okay? Here's what I don't love about that. The judge can still throw it out. They can say, yep, you guys agreed to it, and yep, you as the buyer, you're correct, but no, I think they had a decent case. I don't think they should have to pay your attorney fees. That can happen. On the contrary, if you don't have it in your contract, you can still, if you end up in court and win, ask for their attorney fees. So in my opinion, I don't think it's a huge game changer either way. Obviously, if you do know that you're going to end up in court, it's a little bit stronger to have it signed off on that said, yeah, whoever loses is going to pay all the attorney fees. But it's not going to happen that often. Even if it does happen, it's, like I said, possibly not going to matter. And the reality of it is, I don't want to create any type of objection when the seller's getting ready to sign this contract where they see something about legal dispute, paying attorney fees. So sometimes I'll delete that to just make sure it's not even going to come up as an objection. Because still, like I said, if they change their mind and they breach the contract and they say, we just don't want to close, you still have legal remedies, regardless of if it says that they'll pay for your attorney or not. We've got prorations. These are tax prorations. And guys, this contract, you can download it below. Puts all this on 3 pages, so that it's all worded perfectly. It's great. Again, you can run it by an attorney, but it's all in there exactly the way I do it. So this is just to help you understand what's in there, and these are the key points. If you don't have these key points, you're going to have a problem sooner or later with the deal. I can promise you that. Tax prorations are really simple. Property taxes are annually. Sometimes they're paid biannually, but the thing is, you're not closing on January 1st all the time. So if you close in the middle of the year, taxes are going to get prorated, and they're going to make sure that if the seller's already paid the full year and you close in the middle, that they get credited back for what they've already paid that's now they're not going to own the property during that time anymore. On the contrary, if they owe back taxes, it covers that. The back taxes are going to be paid current by the seller from the proceeds that they're getting for selling the house. We've got the HOA clause, really simple, kind of like closing costs. It just says that we're paying all the costs as the buyer. If there's transfer fees, there's different like capital improvement fees, different junk fees basically that HOAs charge to change the name in their system. We're going to pay those as a buyer. That's considered a closing cost, but it's got its own clause. Now the clause does state that if they have any past due monthly fees or bi-monthly fees, whatever those regular assessments are, if any of those are past due, that they're responsible to bring those current, again, out of the money at close of escrow. We have the deed. This just says what type of deed the seller's going to sign to the buyer. So, you know, just think of a deed like a title, like a car title. That's what a deed is. Very similar, but it's what says who owns real estate. The title policy clause, this just says that we as the buyer, we're going to buy title insurance. You do that from the escrow company. It's one of the closing costs. You're just disclosing that you're going to buy it. The seller doesn't care. It affects them in no way. Actually, it kind of protects them, because if in 5 years you own the property and some neighbor comes and says, wait a minute, part of that property's mine, rather than getting into a he said, she said with the neighbor, or the seller, you know, trying to get a hold of the seller that sold you the property 5 years ago, etc., if they have a valid claim, your title insurance will pay them out. So that just kind of protects you. Now, you can buy title insurance even if it's not disclosed in the contract, but I think it's good to disclose that. Risk of loss. One time I had a fire burn down the night before I sold it. I owned this property and we were selling it, and the night before I got a call from the fire department in Mesa, Arizona, and they said, we're out here at this property. The cat claw on the back of the back patio caught fire, and we were out here, and there's not a whole lot of internal damages, but they did have to kick holes in the ceiling for ventilation. And so it was actually crazy. Our buyer stayed in. We ended up closing. We had to go through the insurance process, fix the little bit of damage that there was. But basically, guys, what this says, this risk of loss, it says that, let's say you sign a contract and you're going to close in 2 weeks. It says in the next 2 weeks, if the house has an insurance claim, it floods, it catches on fire, etc., it says that me as the buyer, I have the option, I can close anyways, and I get to keep the insurance money and use that to pay for to fix everything, or I can back out. Okay, so that's what that's about. Now, the possession clause is typically just going to say at close of escrow, we as the buyer get possession of the property. If it's tenant occupied, possession is going to stay the same. It's tenant occupied. But sometimes you might do a post-possession. So what a post-possession is, and a lot of times we'll use this as extra value to the seller to get a deal. We'll say, hey, what if we let you stay there for a week past closing? Sometimes a month, etc., whatever it takes, right? If it's a good enough deal, you can find a cash buyer that'll deal with that post-possession. And so we just put in the contract, you know, the seller will remain in the home for 2 weeks, or maybe it's 30 days past closing. And then we add into this clause that the title company will hold back, typically $5,000 is the amount we choose, until they're out. So if they have a post-possession and they're getting $200,000 at closing, they're going to get $195 at closing. Title's going to hold $5,000, and once they move out here in a couple weeks or a month, whatever the time period is, the contract, this clause will say that once the seller moves out, the buyer will notify the title company that they're out and release that final amount. We also put a per diem clause in there. So say we give them a post-possession of 30 days and they're not out in 30 days, the per diem, it's part of this post-possession clause, would say that if they're not out by that day, they also owe an extra $100 a day or $500 a day or $1,000 a day. So you can use that. Title companies will like it because it kind of spells out if there's any problems and shifts the risk away from them. But it holds their feet to the fire too. They want to get that last $5,000, and they don't want to pay any extra daily. So that's typically what we'll do if we do a post-possession. We have the final walkthrough clause. You can have a final walkthrough clause that says, you know, hey, within 48 hours of closing, or within 24 hours of closing, or 12 hours of closing, that the seller's going to be out. They're going to give a key to the buyer can do a final walkthrough. And sometimes it's good to do that because it helps make sure the seller's out. You've got a little bit of a buffer. But here's where that can get tricky. If you have that clause and then you assign the contract and the buyer's making a big deal about the final walkthrough and the seller's not out, because usually the seller will be out by the time they the closing day because they want to get their money. But sometimes they forget about that and they wait till the last minute. It's just the nature of a lot of wholesale sellers. Let's be real. So you can, if you have that in there and then the buyer starts making a big deal, it can create this stressful situation. So if you're going to use the final walkthrough clause, which is fine, then make sure to have a clause in your assignment that strikes the final walkthrough clause. So in other words, when you assign the rights of this contract to the buyer, it says, except for you don't get the final walkthrough clause anymore. It'll also say you also don't get the due diligence clause or the funding partner approval clause. So guys, I will create another video for you guys on my assignment contract. That's only a 1.5 page document, and I'll walk you through all the important stuff in that just like that as well. So let me know, leave me a comment if you would like to see that video, and later after we post this, I'll go back to all those comments and make sure to DM that to you so you get it. Also, while you're here, if you're getting something out of this, please crush that subscribe button and hit the bell for more awesome wholesale real estate notifications and tips. After the final walkthrough clause, we've got the acceptance clause. And this is like a due date of when they have to accept the offer. So it would say that, if this contract is not accepted and signed by tomorrow, the offer is null and void. You don't have to do that, but it's a good idea just to create urgency with the seller so you don't send them the contract and they sit on it forever. Hopefully you've kind of, got the fish in the boat, so to speak, when you verbally agreed, so they're going to sign it right away anyways, and I have videos that talk about how to convert like that. But another way you can do, instead of having an acceptance clause, send it to the seller if they want to look at a contract, but don't sign it. And some people will say, no, sign all the offers, shotgun them. I think it's more about the agreement and what's taking place. So if somebody wants to look at a contract they're not ready to sign, I'm not going to send them a signed offer. I'll just send them that, and I'll say, if you like the offer, sign it, and then I'll sign it, as long as you do it quickly while I still have the means to buy your property. So either way, the whole point of this clause, you're just trying to kind of create momentum right now to get them to be decisive and take action and do the property, that they do the deal, that they don't think, hey, I can just look at this contract and think about it for another week. After that, you have time is of the essence. I'm running out of room, so I'm just going to go up here. Time is of the essence. What that clause says is that during escrow, if the title company or the closing attorney needs something from the seller or the buyer, that you will understand that time is of the essence and move quickly doing what you can so that closing can happen on time. So if one person just starts being like, I don't care, I don't even want to sell the deal anymore, and you say, well, you can't, we have a contract, and they say, well, fine, the title company needs me to sign these forms, I'm just going to drag my feet for a month, that you have a contract that says they can't do that, and so you could go for damages if you had to. But that just holds everybody's feet to the fire to move along. And I just explain that when they're signing it, like, look, if they need something from me, I'm going to respond so we can close on time. If they need something from you, please call them back right away. If you have any questions, feel free to call me or call my office. We'll help you out. And that's pretty simple. Prohibition clause. We're getting to the end, I think. Yep, this is the last one. The prohibition clause. This says that this is a binding contract, and the seller can't go out and refinance the property or sell it to somebody else while we're in escrow. And then after that, you have the signatures, the date, and then you've got an executed contract. So guys, again, you can click the link in the description. You can download my exact contract. Once you buy that contract, you'll be on my list. So if we ever make updates in the future to anything, little clauses or stuff like that, you'll get an email notification with the updated contract, and you won't have to try to figure all this stuff out yourself. Again, you can always seek legal advice. I would recommend that you get my contract, run it by an attorney in your market, a real estate investing attorney that's going to understand all that stuff, and you should be good to go. All right, guys, I'll see you in the next video.